Good afternoon and welcome. Welcome to the Farrar's Building Personal Injury Liability Update for 2023 into 2024. I'm David Roderick and I specialise in PI and in clinical negligence, acting for both claimants and defendants. This is our agenda for the talk. Firstly, I will discuss some recent important cases that have developed general principles in negligence. And then secondly, I'm going to highlight significant reported cases from over the past year in various different personal injury practice areas. I hope that's going to take around an hour, maybe 50 minutes to an hour. And there's a Q&A function, I should point out. If there's time to address anything at the end of that time, then we shall. If we run out of time, and in any event, please do feel free to contact me with follow-up questions by email. And this webinar and the recording of the webinar and the slides will also be circulated. These are the references to the cases in relation to the general principles that we're going to look at, so that you can, at your leisure, also look at them and read them if you haven't already. And these are the references in relation to the individual practice areas that we're going to look at. So there is quite a lot to get through, but I'll be succinct, hopefully, on each case, and we shall manage to do so. Firstly, then, to turn to the Supreme Court's first judgment of 2024, and an important one for personal injury, the case of the combined appeals in Poor and others. And as everyone will already know, the decision explains the requirements for proximity in a secondary victim claim when the negligence and the shocking event that affects the secondary victim are separated in time. And that's often the case, of course, in a clinical negligence scenario. The Supreme Court also, in this case, clarifies some of the other requirements in secondary victim claims generally, not just limited to the clinical negligence scenario. So it's an important case more generally too. You'll recall that in all three of the claims, that the death of a close family member had been witnessed by the secondary victim. And that secondary victim suffers a consequential psychiatric illness. And the central point is that the shocking death event occurs a long time after and in a different place to the omissions event, which constituted the defendant's negligence. So the question is, in that type of case, is there sufficient legal proximity between the secondary victim and the defendant? Now, none of the three claims after reaching the High Court level were struck out because the court considered that the past authorities didn't necessarily rule that the relevant event by which proximity was to be measured, broadly speaking, that's the injury manifesting itself event. They didn't find that the previous authorities necessarily ruled that that had to be measured by whether it was synchronous with the negligence. So, for example, in the case of Walters, a case in the clinical negligence setting, after negligent treatment of a child, there was a period of over 36 hours of various interventions, procedures, and moments of potential upset for the mother, claimant, after the negligent treatment. But when the cases got to the Court of Appeal, the Court of Appeal considered themselves bound by Taylor and Novo authority for the proposition that in order for there to be sufficient proximity, the horrific event that's witnessed by the secondary victim can't be a separate event removed in time from the negligence. And when the cases reach the Supreme Court, effectively the decision turns on two principles. Firstly, is the distinction between someone witnessing an external event accident type case and those cases in contradistinction where the claimant is witnessing the later consequences of a breach that has gone unobserved by them. Why should there be that sort of distinction? Unsurprisingly, they're very coherent, logical examples advanced by the Supreme Court as to why that's the case. They're compelling. The clarity and the greater certainty of identifying an external event, for example, as opposed to understanding well in a chain of consequences after omitting to do something in terms of their clinical diagnosis or treatment, where and when does the event or events occur. Also, it's worthy of note that one of an unanswerable piece of logic used by the Supreme Court was in an accident type case. So, for example, someone witnessing their mother or father about to be struck and run over by a bus, that secondary victim can recover for psychiatric injury if it's caused because they've witnessed the imperilment, the threat to a loved one. And they can claim successfully, even if that loved one doesn't actually get injured and the bus swerved at the last moment and didn't strike the potential primary claimant. And of course, that's not a scenario that's comparable in any way to a clinical negligence case. Without that primary victim, there isn't the clinical negligence in the first instance. But also, the second part of the sort of the core of the analysis of the Supreme Court was an inquiry into the effective scope of the duty of care of a doctor and what society can expect. And the conclusion firmly reached was that the duty of care of a doctor just does not extend to protecting a patient's family from exposure to witnessing the death or the disease manifestation in that particular relative. And as I mentioned a moment ago, the decision is also important more broadly in accident type cases as well, because it quite a lot of tidying up, as it were, of the case law was done by the Supreme Court. And that's going to result in some of the other requirements that were hitherto faced by secondary claimants, perhaps being slightly less demanding. So, for instance, there isn't any longer a need to prove that a sudden shock caused the psychiatric illness. There just has to be an ordinary causal connection to a recognized psychiatric condition. There is also no need to prove that the event was of a horrifying standard. That was a gloss that had developed in the case law. It's only required that the accident event was one in which it was reasonably foreseeable that the negligence might cause a psychiatric injury, not some imposed objective test beyond that it had to be somehow a objectively horrifying event. Moving to the next topic, the next generally applicable topic, the next series of cases that I'll look at concern the doctrine of vicarious liability in negligence. Of course, a defendant is only going to be vicariously liable if both stage one can be established. That's whether the tortfeasor is in an employment or in an akin to employment relationship with the defendant, and stage two, that there is a sufficiently close connection between that relationship and the wrongful conduct. And it's within the historical sex abuse cases where there have been a few developments moving forward the general guidance about the stage one and stage two tests that the Supreme Court more recently have set down in Mohammed and Cox and the Barclays Bank series of cases. So firstly, in relation to stage one and the being in an employment relationship or akin to employment relationship between the defendant and the tortfeasor, DJ and Barnsley considered whether the relationship between a local authority and who it had appointed as foster carers who also happened to be family members of the claimant child, whether that relationship was one that was akin to employment. And the case is useful to give a guide as to how the exercise is conducted in terms of very close scrutiny and weighing up of all the features of the relationship that the court has to analyse and assess. So essentially, in this case, there was a balancing exercise between the formal local authority process, the mechanism for the placement with the foster carers, which were obviously indicators of a relationship, perhaps akin to employment. And on the other side of the scales, the familial nature of the relationship between the child and the foster carers, which was the genesis of their relationship, and then stepping into the position of being foster carers in the first instance. And it was balanced, but by a fine balance, the familial nature of the relationship was what outweighed the features of one that was akin to employment. The next case, again returning to the Supreme Court, focused both on stage 1 and stage 2 of the test. Probably more importantly or significantly in relation to stage 2. BXB was very sadly raped by an elder. That's an elected position, but still a volunteer within the church congregation. And there was a prior relationship between B and MS, the tortfeasor, a prior friendship because of their close connection operating as Jehovah's Witnesses. And on the day of the incident, both of their families had been out evangelizing together, but then they'd gone back to the elder's house for Sunday lunch or a weekend lunch. And then the assault occurred whilst all the families were in the house, in the back room of the house. Now, both the decisions in the High Court and the Court of Appeal considered that the defendant was vicariously liable, the church effectively. There was a slight issue in relation to whether it was correct that the trustees had been sued or the parent corporate body in America. That's not relevant, particularly for our purposes. But the defendant was considered vicariously liable before it got to the Supreme Court. In the Supreme Court, in relation to stage 1, so was this an akin to employment relationship, even though MS was a volunteer? Certain hallmarks of what might be akin to employment were identified. There was an assignment of work to the elder, so a formality of instruction. The work being done by him was to further the defendant's objectives as church, as a religion. He'd been formally elected and appointed to the role, and there's a hierarchical structure. So he was higher in the church than other congregation members. But in relation to stage 2, the Supreme Court allowed the appeal, and therefore the claim failed. The reason for that was this: that, as you can see from this slide, effectively the lower courts had perhaps fallen into 2 errors. Firstly, they'd modified the close connection to the employment test, not to ask whether it's sufficiently close connection, but they'd add a gloss to it. Had the elder been given authority by the defendant, and if so, was he abusing that authority? And secondly, they had put significant weight in assessing sufficient closeness and connection on the opportunity for the physical proximity between the victim and the tortfeasor arising because they were in a church relationship, whereas actually properly analysed, they were together and physically proximate when the rape happened just because they had a knowledge of each other and a previous friendship. And to put weight on the opportunity for physical proximity for a tort to happen is simply a but-for causation test for it happening. And but-for causation is insufficient to satisfy the close connection test. Something more than that needs to be the case for there to be vicarious liability. on the part of a defendant for a separate third-party tortfeasor. And then finally, in relation to the vicarious liability, recent cases is the somewhat surprising case of MXX and a secondary school. And this is a case that also deals with both stages of the test. The tortfeasor in this case was an 18-year-old. He was allowed to return to his old school because he wanted to gain some work experience to be a PE teacher. And he was granted that opportunity just simply for a period of 1 week. And he, on some accounts of the fact, he didn't really do much other than just stand there in classes and observe. But during that 1 week, he came into contact with the eventual claimant, a young girl. And after that week, he left the school. He was no longer in a direct relationship with the defendant's school, but some inappropriate text and social media contact, probably sufficient to form the acts sufficient for the tort of intentionally causing harm, started to occur, although he didn't intend to do that. But that progressed and culminated a number of months later, after the 1 week period of work experience, in a sexual assault. And the claim failed on both elements of the test at first instance. And that is perhaps a little unsurprising on first analysis, given he's just work experience on a voluntary basis, given to him as a favour for 1 week, and nothing more than just simply coming into contact with the claimant occurred. But the decision was reversed on appeal in respect of stage 1, because of the real detail in the evidence about the factors that were there present to establish something akin to an employment relationship. We think back to the first case of DJ and Barnsley, and that acute forensic analysis of what was really going on. Notwithstanding the child was only there as a favour on work experience and only for 1 week, there were significant indicators that it was akin to his employment. The vicarious liability decision, however, overall, and the failure of the claim was upheld on stage 2, because what was done 6 months later as a tort in sexual assault was not sufficiently connected with the defendant's, with the relationship of employment. Move on to the next slide now, and a topic on causation, one case in fact, but on novus actus. It's quite a common situation when there's been a negligent accident that thereafter follows some negligent treatment, then that makes the injuries much worse. That's always, of course, very unfortunate for the claimant. Now, not necessarily so unfortunate perhaps for an accident defendant who's seeking to minimise their liability, following this case of Jenkinson. Jenkinson was a case of a high-rate tripper with a fractured ankle, which was followed by negligent fixation surgery, or more than one procedure, and leading to significant losses. The defendant wanted, therefore, to amend its defence to allege a novus actus interveniens. And that was unsuccessful at first instance. The court applying what it took, perhaps what some of us took, to be what was a specific rule, that where negligent treatment follows a tortious injury, it's only medical treatment that's so grossly negligent as to be completely inappropriate as a response that would break the chain of causation. Ultimately, the High Court's analysis of the genesis of that statement in the case of Webb, and then its application in both Webb and in later cases, determined that in fact it was not a specific rule of law, and that also there is not a logical or policy justification for there being such a rule. Whether it is actually correct in practice or not, the High Court judge identified the potential for satellite litigation if you applied such a rule to dispute, well, what's completely inappropriate, what degrees of inappropriateness are there, and it was thought that that was neither logical not justified in relation to the category of clinical negligence cases. So potentially an issue for defendants to consider further bringing in a second party or alleging novus actus. And finally, in relation to general applicable principles across cases that we'll deal with in our practices, is the ability to challenge expert evidence, having not cross-examined an expert. The question, of course, is whether, and if so, in what circumstances can a court be asked to evaluate and perhaps to reject what was an uncontroverted piece of written expert evidence. And the long saga of Mr. Griffiths's claim ended up in the Supreme Court, and ultimately his package tour regulations claim was determined on its facts and whether he proved it to a satisfactory standard by the most senior judge in the land, Lord Reed. But the essential point is that the party, it was determined, must challenge by cross-examination the evidence of any witness, and that's expert or factual witness, on a material point, which that party is then going to argue shouldn't be accepted by the trial judge. There are, however, exceptions to that rule, and non-exhaustive examples were given by the Supreme Court. We can see, for example, where there is an insignificant matter, where a mistake has been made, or where the evidence is just simply manifestly unbelievable, but cross-examining on it wouldn't make any difference at all. Those are perhaps natural and readily understandable, but there are also more useful pathways to still be able to challenge an expert report if tactically or potentially just by dint of circumstances you haven't cross-examined, whether you've chosen to or not. And it appears to me that these are quite useful gateways because of circumstances which might arise that you couldn't anticipate. So, for example, factual evidence is given at trial that's undermined the facts on which an expert report has been based. There's a perfectly acceptable challenge not having cross-examined when that scenario eventuates. Or, for example, if you've given an expert an opportunity to fully answer questions that would have been put in cross-examination by way of a Part 35 questions, and the experts declined the opportunity to do that, that is an avenue for being able to critique and ask for an evaluation of the otherwise uncontroverted expert evidence. So to move now to the practice areas in terms of types of accidents that we commonly encounter and road traffic cases to begin with. Just by way of introduction, of course, plainly RTA cases are very fact specific and they're rarely good precedents for other cases. Specifically in a number of high court cases recently, judges have made it very clear that precedents in road traffic accident cases are probably worthless as factual precedents, certainly. And it is also correct, I believe, to say that over the past year there are only relatively few novel liability points that have arisen in the cases. But I've chosen the following decisions to highlight on road traffic standards of care from the High Court, perhaps because they're most interesting, but also because there are some more general points to note within them, particularly about witness evidence, accident reconstruction, expert evidence as well in particular. And those points may well be applicable to cases we've got in our caseloads at the moment. So in McDonald, the defendant was a lorry driver and he'd stopped in a slip road in the Limehouse Link tunnel. That's a place where you're not strictly not allowed to stop because he wanted to investigate a noise from the lorry. And shortly thereafter, the claimant motorcyclist moved at some speed from the outside lane to exit onto the slip road through lane 2 and lane 1. Didn't realise that the lorry in the slip road was stopped and collided with the back of it. there was quite a bold defence raised based on the reasonableness of the lorry driver stopping because of the noise, notwithstanding that it was in the tunnel. But also, it was defended on the basis that the actions of the motorcyclist had been so grossly negligent as to break the chain of causation. The general point of interest in the case, though, I think, is the analysis that was conducted in respect of the effect on perception response time of the surrounding circumstances. For example, the lights bouncing off, the tunnel conditions. Those features of the surrounding circumstances extended the PRT time significantly for the motorcyclist, in so far as it was not negligent for him to have misunderstood in his manoeuvre that the lorry was actually stationary and not moving on the slip road. It was still, however, negligent for him to have conducted that manoeuvre at the speed that he did. And Hammond and Gibbon is also a case in which perception response time, PRT, and the effect of the angle or other factors, angle and other features of the direction that the driver is looking in, called the eccentricity of the driver's perception. So the effect of the angle of the view and eccentricity on the driver's perception of a hazard was an important feature in this case. Studies were assessed, and those studies were accepted by the court that established that the greater the eccentricity of the driver's perception, the greater the response time will be. And there's a second aspect to this case, which also occurred in the case of Zanata, and that's the importance of assessing all the evidence in the round. That's quite unpredictable to do before a trial, but the factual evidence given at the trial affected the bases of the experts' conclusions. So it's obviously very important to do a standing back exercise once you have an expert's report to make sure that, as far as possible, the factual evidence is going to be given by the witnesses and the facts that are adopted by the expert as the bases for the calculations or the assumptions and opinions that they form tally up. That can be quite difficult to do, particularly in a case such as Hammond, where there was a significant chain of witness evidence that had been given over very many years, as well as the actual cross-examination evidence at trial. And finally, in respect of the road traffic accident cases, FLR and Chandran, again, a case that dealt with perception response time. I think it's worth highlighting, perhaps for two reasons. There was a useful causation argument, quite difficult to succeed on, but the facts aligned sufficiently in this case for the claim to succeed. Breach was very clearly established because the defendant driver was driving only just below the speed limit, but it was dark and wet, and the set of conditions meant that there was very clear breach in being at that speed, even though it was below the limit. But the perception response time was so short. The defendant's evidence was that she didn't see the running out pedestrian until the pedestrian hit her car. And it was determined that in respect of causation, the defendant driver would have had to have been travelling at below 17 miles an hour to have avoided the claimant running out. And it, of course, being at 17 miles an hour, 18 miles an hour, 19 miles an hour, perhaps even 19 and a half miles an hour wouldn't have been negligent. But the court determined that if the defendant had been travelling at the lower speed of 20 miles an hour, which is what in the circumstances she should have been, although it was right that she wasn't at a speed that would have meant that she would have avoided hitting the claimant, at that speed, the claimant would have continued running and would have cleared the front of the defendant's car, thus succeeding both on breach and causation. However, I've really selected this case mostly to draw to your attention because it's just extremely useful as an aid memoir, perhaps rather than for its facts or decision, because the judgment begins with effectively a comprehensive essay in bullet point form on authoritative propositions in RTA law, and also then quite usefully how to go about the forensic assessment of evidence task at a trial in terms of weighing everything in the round and a process of iteration, etc., etc. So it's a really useful, quick read to refresh our memories. Public liability cases. In fact, I think drink is only really implicated in 2 of my examples, so the slide might in fact be a little unfair. The first case is Ashton and the city of Liverpool. And I think that there are 2 points to extract from this case. The claimant was, so important factual background that the claimant was physically and mentally vulnerable. She lived in a 4th floor flat in which there was a low window frame because it was a disabled living flat. The premises itself was a sheltered accommodation hostel type set of premises. And it had window restrictors, but those window restrictors could quite easily be slid out of position. And it was probably known to the defendant that either some window restrictors were broken or that in general they could be detached, and residents did in fact detach window restrictors quite regularly. A number of issues, a number of questions in relation to was this a danger? Was it a breach? Was there in particular a Liability defence effectively, so section 2.5 of the Occupiers Liability Act 1957, because there was a central factual dispute. The defendant asserted that the claimant had climbed out of the window deliberately in a state that was intoxicated, potentially in a mental crisis, and had attempted suicide, but at the last minute had changed her mind and not fallen as far as she might have done. There was a number of references in the written medical record, which seemed to be what the claimant had said she'd been doing. And the claimant's claim was that that wasn't the case. She'd merely been trying to retrieve some drying washing. That was determined in the claimant's favour on the balance of all the facts. The first interesting point was the wide scope of the Occupiers Liability Act duty that was found by the court in respect of a vulnerable claimant in the circumstances whereby she didn't fall out of the window because it was low, but because the defendant probably knew that it was possible for residents to detach the window restrictors, and that sometimes that did occur. The second important point is that even in those set of circumstances, and with the claimant's facts being accepted, that's that she'd chosen consciously to climb out of the window, she was probably intoxicated at the time, she was doing something risky. Those facts were not sufficient to find that she'd made a conscious and voluntary acceptance of the risk that was involved from the danger that the defendant was responsible for. So the section 2.5 defence didn't work. The occupier doesn't have a complete defence. It's just a matter of contributory negligence. And this case might ring a few bells in relation to the factual similarity with the case from about 2 years ago, James and the White Lion Hotel, where a person had been leaning out of a window in order to smoke. Again, in that case, no section 2.5 defence, but just contributory negligence is the finding. So it's a really, really significant threshold, and it remains a very significant threshold to run that defence in an occupier's liability case. And the scope of duty on an occupier is going to be determined by, obviously, as we always argue in every case, all the circumstances that will include the status of a vulnerable claimant in particular. The next slide is quite a sad case for the claimant, obviously. But I highlight this case because of a point of generality. It's interesting in relation to how permissible it may or may not be to challenge the factual circumstances of the mechanics or the facts of an accident at trial when that set of facts departs from a pleaded case. And that's a situation that's obviously not a rarity at trial. And defendants are obviously particularly going to be interested in making the challenges that they can in submissions. And that effectively, effectively happened in this case. After cross-examination, the defendant's final submissions challenged the claimant's account as to the place of her fall, when at the start of the trial, that had been an agreed issue, that she had fallen from decking that was unguarded properly by rails, whereas the outside spar that she was in had steps leading up to it that were wet, but that wasn't negligent. And the defendant made submissions that there should be a finding that the accident had happened in this different location. And everyone would feel very sympathetic to a person in this position. Claimant's counsel, taken completely unawares and sort of surprised by this, didn't challenge that invitation to the judge, that the judge shouldn't be permitted to consider that issue afresh. But on appeal, it was decided that it was procedurally unfair to admit for consideration and determination a previously agreed fact, particularly after all the evidence has been heard. And one can see that that's obviously the case, but it did test the court's analysis, and it was probably quite a balanced decision that had to be made. Après Lounge and Wade is the next case. This is useful for defendants, frankly, because in a nightclub or pub venue or restaurant scenario, quite frequently, an occupier defendant will be able to establish that their inspection and control system for spillages is effectively limited. It's limited to probably an unaudited scheme of instructing the staff or the waiters and waitresses, glass collectors, to keep a lookout while they're on their rounds, to constantly circulate and report and deal with spillages. And in this case, at first instance, the judge concluded that because the effect of such a system, that the timings would mean that each place would only be checked every 15 minutes. Therefore, that was insufficient, certainly in a dark nightclub with a wooden floor by the bar in the early hours of the morning. But on appeal, that was overturned as a reasonably high burden. And there's a validation of such general systems in a way, because if you have a system which is telling all your staff as they go around about their job to keep a lookout, you can call that effectively continuous monitoring. But that, of course, doesn't mean that every area is constantly observed, and nor should it. That would be far too high a standard and a counsel of perfection. So a good case in the Ward and Tesco line of authority slipping cases, if you're a defendant in particular. The next case in relation to public liability cases is a long-running case. It went through 2 appeals. I mentioned the High Court decision, I think, in a talk last year, in which the claimant tripped on the raised curb of a disabled parking bay. And the important factors here was that the defendant was the shop that the claimant wanted to visit, but the owner and operator of the car park was the local authority. Now, both of those parties had degrees of occupancy control. The judgment of first instance, the High Court judgment, and perhaps to a lesser extent, the Court of Appeal Authority, are all very useful to read in relation to any case where you have that scenario where there's more than one party who's got occupiers control, and in particular, someone who is granted a license or by a local authority. The duty on the defendant, the supermarket, the duty as an occupier to physically alter the premises in any way was entirely limited by the limited extent of their control, therefore. So it couldn't be taken to have been expected to have altered the curb, for example. However, its reporting duty to the higher occupier, the local authority, wasn't so limited and was breached by not reporting accidents previously that had happened. Ultimately, however, that wasn't causative of the accident because it was found that the local authority, even if they had been reported to, wouldn't have repaired the curb in time. So a scope of occupier's duty and multiple occupancy defendants. That's an important case to look at. Conscious of the time, and I'm moving through now to employer's liability. And the first case we shall look at is James and Shaw. This case concerned a fall from height while the claimant was working on a framework of a ride at a fairground, and they would absolutely starkly conflicting accounts as to the circumstances in which the fall had occurred. The claimant's account was that he'd been told to do what he was doing, and indeed a more experienced and senior employer was with him when he was doing it, using an implement to untighten a very tight knot on a framework at height. And the defendant's case was that just simply didn't happen. The claimant was alone and he decided to do the job himself, and that was how he was injured. Again, it's quite familiar perhaps to us to have such a stark conflict in an accident at work scenario. It's often asserted that this is just an idiot employee on a frolic of their own. But the case is probably most useful as a reminder for the telling factors that a judge is going to need to decide upon and how to resolve that stark dispute. And so therefore it's also a good reminder of how to prepare a case effectively. So for example, the judge placed weight and ultimately found for the claimant on the basis of an internal consistency from the pleadings through to his statements, supported by contemporaneous references in documentation in the medical records. The defendant, on the other hand, was responsible for relevant and what could be anticipated to be readily available evidence being absent from the trial, and the defendant's witnesses gave evidence in their witness statements that were drafted in a way which just simply sounded like a script that they've been told to deliver. So useful and salutary reminders really of when you've got a factual dispute, the judge has got to hang their hat and peg to a framework of a rational analysis the decision one way or another. So give the tribunal the tools to do that in your case preparation. The next case is Manning, and I don't know whether it's DNATA or Donata, frankly, but this case was a manual handling case and concerned particularly the adequacy of some strapping in the back of a particular lorry that was used by the defendant. And the general point arising from this case is one about dealing with evidence as well. After the claim was notified by the claimant solicitors to the insurer, and the facts and the central relevance of the straps in that lorry were known, the defendant employer scrapped that lorry. And again, it's not uncommon for a claim to arrive at our desks years after the event through an insurer or a broker, and the relevant part or the relevant machine, the equipment, has been destroyed, not been retained. The point of genuine interest in this case was the claimant's submission that there's an evidential rule that where a party either destroys evidence or makes it difficult to adduce relevant evidence, then adverse inferences should be drawn against that party. And that's a principle that derives from a very old case of Amory and Delamere, in which there was the disposal of jewels, which then couldn't be valued, and the highest value of similar jewel was taken in its place, adversely to the defendant. It's a principle that stretches to the modern day, and you'll see the reference there. It was addressed in the Agatha Christie litigation. In this case, however, a distinction was drawn between careless destruction of the lorry, which is what this had been. The defendant availed itself of some upset and difficulties in communication during the COVID pandemic, and it was determined that the destruction wasn't a step that had been deliberately designed to thwart the investigation. So that's an important distinction if you're in the scenario where the crucial bit of kit is no longer available. And also there was a further argument against the claimant, which I think helped tip the balance, that the claimant themselves had the opportunity to photograph that particular strap and had indeed photographed parts of the lorry in which the accident had occurred, but not the key area. No negative inferences were therefore drawn in Manning. And now moving to Rose. Rose is the third and final employer's liability case that's useful generally in respect of the case law from last year. It is a Scottish case from the sort of equivalent of the English and Welsh High Court. Of course, Section 69 of the Enterprise and Regulatory Reform Act of 2013 applies to Scotland. The facts of the case, they're not necessarily particularly relevant for our purposes, but what is useful is the case assesses the interrelation between the statutory health and safety regulations and common law claims in negligence, and how ERA 2013 has affected that relationship. The Outer House of the Court of Session looked at both English and Welsh and Scottish cases which have decided whether there was negligence, where it's also possible to point to a breach of statutory duty. So the High Court case of Cockerell, and Tompkins and Tapp. But the court identified that there's been probably an erroneous approach in some cases, namely familiar submission, that if it's a criminal offence to fail to comply with the statutory duty, it's going to be inconsistent and therefore quite hard for an employer to argue that it was reasonable in a civil, in the civil aspects of an action against them, reasonable to have been in breach of duty of that statutory duty, but still not negligent. And the court determined that's incorrect, and strongly so. Criminal liability and common law duties operate on entirely different planes, and it was concluded that the relevance of statutory regulations is likely to be limited to just simply providing factual support to identify the types of risks and the types of controls that are common to particular circumstances, but the regulations don't hold any residual power that informs what the common law duty of care is. And lastly, moving to sports law, the photographs on the screen are from the actual case that we're going to focus on. As you look at it, the one on the left is the moment before the tackle, and the right is the tackle. Sanuska and King. And this case was one that garnered quite a lot of publicity at the time. And there were obviously quite tragic consequences for the claimant of a relatively innocuous afternoon playing amateur rugby, but then a very bad tackle, probably when the perpetrator defendant was out for revenge rather than fairly contesting the game. But the case is interesting for setting out, again, the parameters for a finding of liability during sporting activity. The standard of care is obviously going to be influenced by the circumstances. It's relevant in this case that there was a developmental league that the players were playing in, that there was a backstory to their previous games, and indeed the defendant and potentially claimant's relationship on the pitch in the instant game. So on the one hand, in relation to the parameters for liability being found during sporting activity, liability isn't going to attach simply because a tackle is illegal, or even because it's dangerous by the laws of the game. But on the other hand, there is not such a latitude in the sporting environment that you have to, as a claimant, establish that the conduct is reckless or it's of a very high degree of carelessness for a finding of liability to be made. It will always return to, in respect of what is expected as the reasonable standard of care in all the circumstances. In this case, that tackle was said by one of the experts to not have been witnessed in more than a handful of times in multiple decades of experience of rugby. That's the end of the talk in terms of the perhaps quick trot through important cases of last year. Clicking into my Q&A function, there aren't any open questions at the moment. It has been almost 1 hour. So let me just extend the invitation again to say that there are details there on the screen. And of course, please do send me any questions by email or telephone that you want to. Otherwise, thank you very much for your attendance and hope you all have a pleasant evening. Thank you.